talk on their feet in law school, so it's okay.
B,
That was-
the legal entry is 115-A.
Dash.
And then we'll put the A for the attempt.
Okay, no problem with that, but yes, the
Okay.
first question.
It was each writing for one.
All right. So, understanding all that, Ms. Stringer, are you pleading guilty to these charges? Are you doing so freely and voluntarily today? All right. Counsel, would you like to voir dire to get the facts that support the pleas?
Yes, I would, Ron.
I've shown an incident date here, Romulus, April 28th this year.
So, Ms. Stringer, I'm going to question. So I'm going to take you back to April 28th, 2026. On that date, did you visit the address of 15085 Mesa Way in Romulus?
Yeah.
And is that in Wayne County, Michigan? And on that day, did you walk up to the door of that house and start knocking on that door? At some point, did you use your foot to strike the door?
I can't hear. I heard yes, and then I didn't hear what the rest was. Okay.
And in so doing, did you cause even a slight amount of property damage? Unknown. I mean, I think there might be some memory issues here, so I also would have no problem with the contest plea.
Your Honor, I will subscribe to that.
I'm all right with that.
Okay.
Hold on. You understand if you say no contest to the charge, you're literally saying, Judge, I'm not fighting that charge. So if I find facts that support the plea, we go forward and there's a sentencing. You understand that?
Just a moment.
Sure.
My client is okay with the no contest plea.
Okay.
And
You satisfied with the facts, Mr. Kaplan?
Yes, Your Honor. This report reflects that on the date showing the complaint judge, this young lady, the defendant, visited a home, not her own, caused a slight amount of damage to the front door, and also tried to enter the home unsuccessfully without permission.
Satisfied?
that's
I am too. I'll dismiss the original count one. I'm inclined to send her for a pre-sentence investigation, but I'll let you try to talk me out of it.
Your Honor, what I feel, if I may, is that this was an isolated incident. It was actually a mistake. I think maybe she was associated with a bad hombre somewhere, but at any rate, she seems to be doing well. I think you could set the state.
I agree, Judge.
Okay.
This $500 restitution that's set there. I believe that you can come up with a reasonable probation on the spot and speak.
Okay. All right. Go ahead.
Your Honor, Ms. Stringer is 20 years old. This is her first contact with the time system. Like Mr. Kaplan said, I think this was an isolated incident. She has worked before. She's looking for work now. I think this pending trial has made it difficult for her to secure her next job. She intends to, re-enter the workforce.
Okay.
We're grateful for the misdemeanor reduction. Hope that these offenses get expunged sometime soon. In the meantime, Your Honor, we would ask for simply imposing the restitution that was in the agreement. If there would be any probation, that it be minimally intensive. She lives in Taylor,
Yep.
so not exactly stone's throw away. So I would just ask that any probation be limited to, you know, a few check-ins, maybe, you know, alcohol test.
Gotcha.
Or rain, or intensity classes, or anything like that.
We agree on
All right, thank you. All right, Ms. Stringer, where did you work last time you had a job? Who were you working for? How long were you there?
We started like 2-3 weeks before.
Okay. How about the job before that? What were you doing? Okay. All right. So this is a little bit off topic, but before you leave my building, go downstairs and ask if Mr. Taylor's still here. He shouldn't be at lunch yet. Ask Mr. Taylor what he's got for job opportunities in the area, like Romulus or Taylor. He keeps track of job openings for like entry-level jobs. He's usually got a pretty good list, so something might reach out to you. All right, anything else you want me to know before I sentence you today? No? I can't hear you. Okay, all right. So I've got a problem with these restitution orders. Do you have the ability to pay $500? Not today, but I mean, can you get this paid in the next 5 months, 6 months? You sure? All right,
Right on the average, yeah.
yeah,
We recommended $300 restitution.
$300?
Morph assessed it, how much damage?
All right. It's your recommendation. I'll take it.
Thank you.
She's not gonna argue with you. All right, so you can get that done? Okay. Was there any indication there was some kind of substance abuse involved in this?
No, don't do so, Judge. They,
You got a driver's license, your valid license to hold on yards? Okay. All right, well, the $300 has got to be money because that's restitution. I'll give her the option. I could do some community service or work, excuse me, I could do some work program time instead of fines and costs. She's not working right now. She just have to be here at 8 o'clock in the morning. She picks the days.
Would have to be work program as opposed to community service.
Well, I like work program because then she walks out of here, she knows she's got a schedule for X number of days. She bangs those days out. She doesn't have to worry about finding someplace to go. She just shows up here and does it. I'll give her fines and costs and give her time to pay.
Could we just do one in lieu of the other so she can kind of choose what works best for her after today?
Sure. Reasonable. All right, so here's what I'm going to do on 750.3806. Well, first of all, on both charges, it's 12-month non-reporting probation. That just means stay out of trouble. On the first count, which is the 3806, that one, I'm going to put the restitution on that file and $400 fines and costs or 4 days on the court work program. On the attempt illegal entry, it's another $400 fines and costs or 4 days on the work program. What I'm inclined to do, counsel, is give her until June 12 on the first file to do the money or the work days, and then give her until July 15th on the second file. So that way she just knows she's got 30 days to either do the $400. In any event, she's got to get the 300 paid, but she's got the first file, she's got 30 days to do the 4 days or the $400, and then she's got another 30 days to do another 400 or another 4 days. And if she wants to pay 4 and do 4, however she wants to work it out. Does that make sense? Sure. You got the bodies we need for the next one?
That we appreciate, court's, assessment here. Is it possible just to give a little bit more time? What if we just make it like a, instead of a 30, 60 day, make it a 60, 90 day situation?
No, I'm not gonna wait that long to find out I got a problem. If she wants to say, I'll do the money, then we'll just put her on a payment plan on the money. If she can't make the decision today, I gotta limit it. But if she wants to make the decision today, money or time, then we can work with that. But why don't we pass on this so I can call another file? You guys take all the time you need. Fonville.